I'm actually saying
allow me to just
on the question of this.
Allow me to say this. Let me finish first. I have interjected. I have interjected. Allow me to finish.
Now you are before me.
He's here. Take plea. Take plea. Baraka mapesi. Instant copy. We don't want you to ask the circumstances that led him here, because your duty is just to be a conveyor belt, right? Guilty or not guilty. It can't be the instant coffee. It's a due process of the law. And all these are connected. So you can't be invited to ignore a high court order that has been violated. And you have been told, let them go and do it in the high court.
And I think I've mentioned that we indeed recognize that high court order, but I've again mentioned that it is silent on what happens when an offense has occurred.
What he does not understand, which I'm struggling to explain for him to understand, is this. The violation of the court order, and I hope my friend, Mr. Sonye, admits the violation of the court order.
That is not the case.
If there is a court order, whose tenor all of us know, we are all lawyers. And we are saying, defer the plea to a later date. Let the High Court put this house in order. It happens many times. I've come before this court to defer pleas for somebody who just missed a bus from Alego to Nairobi. And the court accommodates. This is not even as simple as somebody missing a bus. This is a case of a High Court being disobeyed.
Your Honor, allow me to interject, sorry, with respect to my colleague. I hope you are at the point of a reply, a response, so that we don't reopen.
We are not reopening. He's finishing.
I'm not reopening. I'm actually saying,
allow me to just
on the question of this.
Allow me to say this. Let me finish first.
I have interjected.
I have interjected. Allow me to finish.
Now you are before me.
Yes, Your Honor, may I make my interjection, even if it is not merited?
You
I
seem
think
to
I
be
have a right to
objecting
say
something.
Yes.
What is it?
I'm praying that the defense does not reopen their case because we do not have an opportunity. I'm not suggesting he has, but I am hoping he should not. He said it there. Because we will not have an opportunity to respond. That is number one. Number two, in response, and lawyers know this, he should be responding on issues of law, not factual matters again. We are past that level. It's very important also to his client because of the need to expedite this matter. Thank you.
Proceed, Counsel.
Thank you very much. Thank you very much. Thank you very much. Thank you very much.
Proceed, Counsel. I hope you're coming to a close.
I was actually, it's just even disrupted my train of thought, but I'll get there. So just allow me 1 minute. Within 5 minutes, I'll be done. Yes. The point I was making, let me start from that. That plea deferring happens every day. And I gave an example, an illustration to make it easy for them to understand. Even somebody missing a bus, when you explain to the court, you take another date, they come. If you are sick, the court can defer the plea. In this case, we are saying a court order of a competent court has been violated. In fact, 3 court orders are being violated in the face of the court. That is a substantive ground that, in my view, is even greater than missing a bus. And that will give the applicants an opportunity to raise and canvass those violations of court orders before the High Court. And they will participate. We are not going to do it in their absence. Your Honor, I want to say this. What we are asking of the court is not novel. It happens. In the case of Miguna, similar issues arose. where the High Court had given at one point no less than 5 orders, which the DCI, the DPP, and the IG were ignoring. They insisted on registering charges. And the court told them, this house is not in order. Please go to the High Court. Let's put that house in order in terms of how to proceed and recognizing our orders and respecting them. Then the court, once they give directions, the house is in order, you can come back to it. That is what we're asking of this court. Just defer. The High Court will put everybody in order. Similar circumstances in the case of TJ Kajol. So it's not unique, it's not novel. Courts have done it. And it brings me to my final point, which Mr. JV, who I play football with, is not able to respond to, because I score most of the goals when we play. The prejudicial effect. What prejudice will they suffer? No mention. None. Zero. What loss will they suffer? None. Zero. This court is here every day. My friend Bishop normally says it's like a judiciary. A judiciary is where cases don't come to an end. So the courts will be here. They will have their day when it comes. They can come even next month. Senior Muite only asked for 4 weeks. We will be here. They will be here. No prejudice. But to subject a party whose rights has been violated, a party who has been dragged before you in disobedience of court orders, to proceed in an exercise that does not give him an opportunity to get redress at the court whose orders are being violated, is prejudicial. And violation of rights can never be cured. Well, the courts have said it. No money can compensate violation of rights. No money. That's why it's called compensation. It's never enough. It can never be. So the final point, Your Honor, is that as we retire to consider the ruling, I reiterate my plea to this court that the orders of the High Court stopping the arrest, detention, and commanding the forthwith release